don't qualify, we won't go Spain.
Oh, it's okay, we got like...
Okay.
So who is the president of this?
Brandon. His name is Brandon, my name is Mark.
Okay.
Yeah, so resume as the president. He's wearing a suit.
Did you wear a suit for this?
For which one?
Like 2 judges.
Yeah, I figured I should probably.
No, we got wear suit.
Because we're gonna be on campus.
No, we got wear suit for guys now.
So I'm so sorry for failing you, bro.
No, it's okay. I thought you were gonna wear a suit too. So.
No, I genuinely wanted to ask you, but then by then I already had left home, so I was like, it's too late.
Okay. Mr. President, Mr. Arbitrator, good evening. My name is Samantha Chong, and with me is my co-counsel, Mr. Ameerul Putra. We speak on behalf of the appellant, Anna Benitsky. We will speak for 7 minutes each, reserving 1 minute for rebuttal. The reason we are here before this tribunal is to decide the appropriate sanction that should be handed to the appellant for committing an ADRV. To decide the appropriate sanction, we must look to 3 things: her intention, degree of fault, and proportionality. We submit that the appellant should not be sanctioned with any period of ineligibility or sanction and may be given a reprimand instead for the following reasons. First, the appellant did not intentionally commit the ADRV. Hence, if there is any sanction that is to be given to her, it should not be the maximum of 4 years, but should be reduced to 2 years. Second, her sanction may be further reduced because she has no significant fault or negligence. Instead, she has a low degree of fault, and any sanction that may be given to her should be further reduced to not exceed 3 months. However, ultimately, we believe that it is disproportionate to sentence the appellant to any period of ineligibility because she has not detracted from the integrity of sport. Should the panel find in favor of the appellant, we ask that the respondent bear the cost of the proceedings and also contribute to the cost the appellant incurred by hiring the private laboratory to test the supplements and by hiring the expert witness, Dr. Narayanan. Turning proper to my first submission, we submit that the appellant her sanction should not exceed 2 years, as per Article 10.2.1 of the WADA Code, where it says that where the athlete proves a lack of intention to commit the ADRV, then their sanction should be reduced from 4 years to 2 years. To prove lack of intent, the appellant has to prove lack of direct intent and lack of indirect intent, where indirect intent is considered something like recklessness. First, the appellant has no direct intent as she accidentally consumed Ostrin when she ingested Sasquatch powder that was contaminated by the manufacturer. In WADA and JADA Mazaki Toyoda, the panel stated that where an athlete cannot rely on an individual evidence to prove their claim, they may rely on a cumulative combined multiple pieces of evidence to prove and strengthen their claim. In this case, this is called the strands in the cable method. Using the strands in the cable method, we can prove that the totality of the evidence shows and proves on the balance of probability that the appellant's claim that she accidentally ingested Ostrin when she consumed the contaminated Sasquatch powder is more likely than not true. First, Global NutriCorp, the manufacturer of Sasquatch powder, has been sued multiple times for contaminating their products. This increases the likelihood that they may have contaminated Sasquatch powder as well. Second, Dr. Narayanan's scientific analysis also corroborates with the theory of accidental ingestion. This is found in Exhibit 4, Expert Witness Statement. He uses 2 modes of scientific analysis, toxicology and pharmacokinetics, and both of his scientific analysis concludes, with both of this scientific analysis, he manages to conclude and come to the same conclusion as the appellant. It is thus highly improbable that he comes to the same conclusion using objective scientific evidence if it was just pure coincidence. Therefore, in all likelihood, logically, it seems that the appellant was truthful in her claim, thus leading to the scientific evidence corroborating with her claim. Third, her conduct of spending a lot of resources and incurring a lot of costs in hiring the private laboratory also corroborates her innocence. It is unlikely that she would spend so much money trying to find the source and even allowing and supporting the private laboratory to test multiple batches of Sasquatch power if she had self-contaminated the Sasquatch power herself, because testing other batches and revealing a negative finding of Sasquatch power would be incriminating evidence against her case if she had self-contaminated. Overall, all the evidence suggests that the appellant had accidentally ingested Austrian instead of intentionally ingesting Austrian. Additionally, yes.
I have a question. So I understand that you're trying to put forward an argument that the athlete had no idea what they were ingesting, right?
Yes.
So are you trying to say that the athlete's lack of knowledge or education is enough to remove the responsibility? And if that is so, then wouldn't that encourage a lot of athletes in the same tier to do the same, and encourage all the other athletes to stay ununiform with the anti-doping risk?
I understand your Mr. Arbitrator's concern. The appellant's lack of anti-doping education is not due to her fault of any kind. Her scenario, where she is an athlete from Turkmenistan provides an anti-doping education that was in English, her non-native language. She did undertake that program. Additionally, Turkmenistan and its national anti-doping agencies have failed to provide supplementary education via the form of news reports, assessments, or other training materials, and this has severely impacted her lack of knowledge.
Right.
In this case, it's a specific circumstance where the athlete does really have a lower degree of awareness of the risk of contaminated supplements compared to other cases where athletes have the opportunity to have effective anti-doping education, and where it is actually part of their national anti-doping agencies do offer supplementary materials.
By using this flow of logic, wouldn't this open the floodgates for other athletes who are non-native English speakers? And they would just rely on this sole fact that because the anti-doping education was done in a different language, which was not my mother tongue or native language, they can rely on this defense. So what do you have to say about that?
Well, this current point that we're proving indirect intent is focused on whether or not she did conceive the risk. This is a threshold that we have to cross.
Right.
The fact that she does not know and is ignorant of the risk of contaminated supplements is we're merely looking at her subjective state of mind. Therefore, her lack of education here would affect her subjective state of mind.
Okay.
Yeah.
Thank you.
Counsel, paragraph 3, page 1 of the new problem says that she did not disclose Austrian on the doping control form. Can you explain that? Is there an explanation for the refusal to disclose? Lack of disclosure?
If I may refer, Mr. President, to Exhibit 5, Doping Control Form. The doping control form asks, it is in the same, yes, it's in the same package.
Yes.
The doping control form asks for declaration of medication use and blood transfusions that last 7 days. Electrolyte powders are relatively innocuous and would not be considered medications in any sense of the word.
But this is the substance in the
dispute, which was found in the body, right? Through the Sasquatch.
Yes, they found Austrian in her blood, in her urine sample. Yes.
So is this the reason for the sanction?
Oh.
Or
the appellant is sanctioned with by Article 2.2 of the WADA Code, which basically states that if there is any prohibited substance that is found in the athlete's body, they have already committed a strict liability anti-doping offense. They found traces of Austrian of 0.05 nanograms per milliliter of Austrian in her sample. The appellant then claims that she does not know how or why this Austrian entered her body.
so your argument is there's there's no duty to disclose?
No. The argument is that the athlete did not know what she was consuming at the point in time. And the Sasquatch sauce or the gel had such ingredients which essentially made the athlete liable.
Overall, since the appellant did not have subjective knowledge and did not conceive of the possible risk of supplement contamination, she had no indirect intent to, and she was not reckless in her regard. Therefore, she did not intentionally commit the anti-doping rule violation, and her maximum sanction, if any should be given, should not exceed 2 years. My co-counsel will now bring you through the reasons for why the sanction should even be eliminated.
Mr. President, Mr. Arbitrator, good evening. As earlier introduced, my name is Ameerul, and I too act for the appellant, Ms. Anna Bernetsky. I'll assist this panel on the fault and proportionality analysis of the appellant's case. Now, to assess an athlete's level of fault in anti-doping, the panel must consider two separate limbs. Firstly, the objective limb, which asks what would a reasonable athlete have done if they were put in the appellant's situation, and then move on to assess the appellant's subjective fault, which asks, given the appellant's particular background or circumstances, were her actions reasonable? Now, moving on to objective fault, the appellant submits that she had a low objective fault because she met the reasonable athlete standard of care expected in this case. Put simply, a reasonable athlete, if put in the appellant's situation, would have done the same checks and would have missed out on the same steps that the appellant also missed out on. At the lower tribunal, the appellant testified that she did 2 layers of checks, which is her own check against the WADA prohibited list, and then she used the Safe Spot Check app to verify this result. Now, regrettably, the appellant had missed out on conducting an internet search, and also had missed out on consulting a doctor or nutritionist before consuming Sasquatch Power. But the appellant submits that a reasonable athlete would have similarly done the same thing. Now, this is because the reasonable athlete standard of care is not static. If the conceivable risk that Sasquatch Power was contaminated, or that consuming Sasquatch Power would result in a violation is low, then the reasonable athlete standard of care is similarly lowered, in a sense that we expect less from a reasonable athlete if the risk of contamination is low. The appellant submits that the conceivable risk that Sasquatch Power was contaminated is low because of the following 3 reasons. Firstly, Sasquatch Power is a hydration supplement and an electrolyte powder. Now, electrolyte powders are not meant or are not going to reveal any suspicious ingredients, as opposed to a dietary supplement which sort of promises a certain effect. Maybe they promise an effect of muscle building or fat loss supplement. Now, a reasonable athlete would not think that a hydration supplement would contain any suspicious or prohibited substance because it does not promise any performance enhancing effect. Secondly, if you look at the tub of the Sasquatch Power, the most prominent mark on the tub is a large green circle graphic, which states that Sasquatch Power is 100% pure and it's filled with clean ingredients. Now, this is found in Exhibit 2 of the package. Given the fact that this is the most prominent mark on the tub, a reasonable athlete would take some assurance about that and think that Sasquatch Power is indeed clean and permissible. And lastly, the displayed ingredients of the Sasquatch Power does not include any prohibited substance or suspicious ingredient. Now, it stands to reason that the reasonable athlete standard of care should not be pitched to the same standard as if the displayed ingredients did show any prohibited substance, because in that case, if an athlete were to miss out on searching, then it would heighten the risk of a violation. So in totality, the panel should find that the appellant had low objective fault because she has met the lowered reasonable athlete standard of care because the conceivable risk that Sasquatch Power was contaminated was low. Now, I note my time, if I may have an extension of time.
Yes.
Much obliged. Now, moving on to subjective fault, the question before this panel is basically what parts of the appellant's background or circumstances made it reasonable for her to do only 2 layers of checks and miss out on conducting internet search and consulting a doctor before consumption. And the appellant submits that this is for 2 reasons. Firstly, the appellant had an infrequent and ineffective anti-doping education, and the appellant's home nation and its national anti-doping organization do not provide her with any doping materials or any developments on anti-doping.
Counsel, if I may, I mean, but then is she required to, right, at least be educated through other means? And I'm guessing that did she take steps to further educate herself?
Now, Mr. Arbitrator, we are not, Mr. President, we are not disputing the fact that she may have had to take the initiative to further educate herself in this regard. But as of this moment, we submit that the fact that the only education that she was exposed to, now we have no facts to suggest that maybe she had a choice of choosing the education in English.
So there's nothing on the facts?
There's nothing on the facts, Mr. President. So therefore, we submit that this generally affected her understanding of anti-doping risks, which also means that she has an impact risk assessment. So she could not imagine that a clean supplement with permissible ingredients would be contaminated, and therefore she could not be expected to do more than the 2 checks that she already did.
I'm so sorry to interrupt, Counsel. I have a question on paragraph 7.1. Paragraph 7.7. It says that she did not conduct an interval research for the manufacture of Sasquatch powder. Had she done so, she would have found multiple litigation cases. So my question is, you accept that the internet searches and medical consultations are commonly regarded as basic precautions, right? So why should the tribunal lower the standard of care in this matter?
Now, Mr. Arbitrator, the panel should lower the the standard of care expected from this particular appellant because of her general circumstances in the infancy of her career. It is the fact that in the infancy of her career, she has not been exposed to any of these anti-doping updates. So it likely stands to reason that she would not have cultivated the habit to conduct internet search as soon as she picks up a product or picks up a supplement. Now, because of this circumstance, we submit that this circumstance will actually affect this standard that we expect of this particular appellant because she had no knowledge that she should have to have done so.
Okay, so are you trying to put forward an argument that the label assurance and the application on the phone itself should override the CS tribunal's expectation?
Could you repeat that, Mr.
So are you trying to say that the label assurance on the Sasquatch powder and the application which she used to scan and see whether if it's allowed or eligible, if she's allowed to use this powder, should override the CAS jurisprudence and the expectation, the standard of care?
Well, Mr. Arbitrator, it's not so much to override, but we submit that in this particular case, the subjective circumstances are such that it should make it reasonable that she only did the 2 checks that she did.
Okay.
Now,
Counsel, I may just. So the respondents argue that she's an avid social media user at paragraph 2, facts of the record. So shouldn't she have just done a few searches online on social media just to double check on everything? I mean, isn't that reasonable to expect of an athlete? I mean, that's what the respondent submits, right?
Mr. Arbitrator, although we agree that we put it on the record that she is a copious social media user, but we are submitting that her background just did not make her think that it was reasonable or like that she needed to do an internet search. So absent any of this like objective warning signs that she should have done internet search, the fact that she's a copious social media user is not relevant to this analysis. As such, the panel should find that the appellant bore a light degree of fault commensurate with 0 to 8 months period of ineligibility. And this ties to my last submission, if I could have time. The appellant's last submission is that the panel should exercise further proportionality to reduce and eliminate any period of ineligibility to be imposed on the appellant, because to impose any ban is a disproportionate response. Now, if I could have now that imagine, by way of illustration, imagine this scenario where an athlete can prove to the court or to the panel that he bore no fault or negligence, yet the amount of prohibited substance in their system is so large that they actually gain a competitive advantage over their competition. So in this case, the athlete's continued participation actually impinges on the elements of fair competition that the WADA is concerned with. But in our case, while the appellant, we admit that she did bear some fault, but the fact of the matter is that the amount of Austrian found in her system is so low, it does not impinge on any fair competition. So that is why we respectfully request this panel to eliminate the period of ineligibility, because her continued participation in any competitions do not impinge on fair sport or the integrity of sport. As such, the appellant has proven that she has lacked the intent, that she bore a light degree of fault, and that proportionality should reduce her sanction altogether. Therefore, we request that this panel hand her a sanction of a reprimand and that the respondent bear the cost of these proceedings. This concludes the appellant's case.
Thank you.
I just want to take a mic. It'd be easier for you to speak.
Oh. That's louder. No.
Do I need to push anything?
Yeah, you just press this, then it's green.
Okay.
Yeah. This is green?
That's green.
Mr. Arbitrator, my name is Darius and together with my co-counsel, Ms. Kyran Narayanan, we speak for the respondent, the World Tour Wrestling Federation. We'll each speak for 7 minutes and respectfully reserve 1 minute for rebuttal. Athletes train for years, decades even, and this is why doping is perhaps one of the most cardinal sins of sport. It minimizes the efforts of clean athletes, which is why severe sanctions are imposed. There is no dispute Austrian was present in the athlete's body, and so what the panel has to decide today is whether its presence, which was detected right off the bat of a record-winning performance, could truly be said to be unintentional or without fault. I'll be addressing this panel on the sanction to be imposed, a 4-year period of ineligibility, because the appellant cannot disprove there was intent. My co-counsel will address the panel on the alternative sanction, a 2-year period of ineligibility because of the appellant's significant fault, and the issues of proportionality and cost. Turning to the question of direct intent. The appellant has suggested that based on Dr. Manan Sean's expert report, which is outlined in Exhibit 4 of the evidence, that there was only accidental ingestion of the contaminated Sasquatch powder. However, the respondent takes issue with this on 2 points. The first is that if Mr. Arbitrator and Mr. President were to look at the second part of the first page of the report, it states that it is inconsistent with a scenario of intentional use for muscle growth, or for doping rather.
Sorry, where is it again? Exhibit 4, right?
Pardon?
Is it on
Exhibit 4. So, in the second part, for context.
Oh, okay.
So he relies on doping dosage intended to build muscle mass. But if I may point the members of this panel to the second page of the agreed facts, it states on the 4th point that Ostrin is known for its potential to increase muscle mass, enhance strength, support fat loss, and improve overall metabolic health. Now, Dr. Mananshan only focuses on one aspect, which is increased muscle mass, but he has ignored the other benefits. So, for instance, it supports fat loss, which is relevant in this instance because as a toe wrestler, the appellant would need to be able to maintain her weight to remain in a certain weight category. This has direct...
Counsel, if I may. But because here it's just a small amount, right? 500 milligrams. It's just a small amount.
Indeed.
And appellants argue that a small amount of the prohibited substance indicate a lack of direct intent. And they cited a case here. So would you have a response, or can that be explained?
Mr. President, if I may refer you to the Exhibit 4 once more. Dr. Mananshan states that his perspective, or rather his analysis, and this is in the same spot as the muscle mass portion, it depends on the window of concentration. So it is equally plausible that the appellant had consumed Ostrin days or weeks in advance at a higher dosage, which would be consistent with muscle growth or any other of the purported benefits. And so the point on it being too little does not suggest that the appellant had no direct intent, because there are still a possibility that there are benefits for her.
Right. But even so, because the case they cited, Jerison Lawson, that one, there was 0.65 milligrams, and they held the athlete had proven on balance that there was a lack of intention, right? So it's 50 milligrams versus, there's a case here that is in their favor. Any other comments or response?
Mr. Arbitrator, I am unable to assist you on the facts of Jerison Lawson itself, but it is still the respondent's position that because the appellant has not proven that they had consumed the quantity of Ostrin Dr. Mananshan asserts within the asserted time frame of 12 to 24 hours, it is still very much possible that they had consumed a higher concentration, because this 0.05 nanograms per milliliter concentration relates to the amount of Ostrin within the appellant's urine, and this is the amount that was secreted at that point in time, but it does not tell us how much the appellant had consumed in the first place. Secondly, the appellant also made much note of the fact that the evidence of diligent attempts to find out whether the source of the Ostrin can prove her lack of intent. However, the respondent contends that evidence of diligent attempts have been found to not be an admissible means of proving. This is outlined in the Masaki Toyoda case at paragraph 190, and I quote verbatim that such modes of evidence would result in an unacceptable prospect that guilty athletes could spend their way out of trouble by engaging in extensive post-violation investigations. The respondent submits that this mode of proof simply cannot be admissible before this panel because as a matter of policy, it would only be able to favor athletes who would have the means and capability of actually conducting extensive post-contamination, post-ADRV investigations. Thirdly, the appellant also makes much note of the fact that she is unable to understand English. But if I may refer your panels to Exhibit 5, which is the doping control form which Miss Anna Benitsky signed on August 15th, it shows that the appellant was able to answer and fill in the blanks in English, and she was able to understand things like declaration of medication use and blood transfusions, which are not elementary level English. Further, the appellant, by her own words, has used the safe spot check, and I refer the members of this panel to Exhibit 3, where you can see that on the screenshot of the application, it is written in English. And so on this basis, the respondent contends that the appellant cannot rely on a lack of English to indicate that she had she did not have intent. It is for these reasons the respondent submits that the appellant has not made up the fact that she did not have intent.
If this panel is not with my co-counsel, the respondent further submits that the appellant has failed to make out the case that there was no significant fault or negligence, and that the principle of proportionality does not apply. The appellant should also award the respondent a contribution of 10,000 Swiss francs towards the respondent's costs. First, the respondent had argued that the standard should be lowered with regards to making out a case of no significant fault or negligence. Sorry, the appellant has argued. The appellant has argued that the standard should be lowered for a few reasons. One of them being that the appellant was consuming a hydration supplement, and thus there was no reason to suspect there would be any prohibited substances. However, the question before this panel is not whether the appellant had fulfilled her duties in checking for prohibited substances, but rather whether she had sufficiently checked for the risk of contamination. And for that inquiry, there are objective elements provided in CAS jurisprudence, particularly in the landmark case of Marin Silic. CAS jurisprudence has identified a number of precautions as a guide to prevent ADRV, including ensuring that the product is reliably sourced, reading the label of the product used, cross-checking all the ingredients against the list of prohibited substances, consulting appropriate experts in these matters and instructing them diligently before consuming the product, and most pertinently, conducting an internet search of the product. Not only did the appellant blindly take the shop assistant's advice, she failed to inform her that she was an elite athlete. She failed to do a simple internet search, which would have reviewed the litigation against the manufacturer for similar contamination issues, and she failed to consult a doctor or nutritionist, despite the explicit express warning on the label of Sasquatch Power. In fact, she used the app Safe Spot Check, which did not say there was no risk, but that there was a low risk, which still pertains to some risks that had been alerted to the appellant. Furthermore, on the subjective side, which would in fact increase the standard expected of her, contrary to the appellant's arguments that the standard should be lowered, this was a new product she was taking. And in CAS jurisprudence, particularly in the case of Marin Silic, this means that the standard should in fact be higher and should not be lowered because this was a new product she was taking. And thus, there's a even higher level of care on the appellant's part that she had failed to take. Consequently, as the appellant is unable to prove that her ADRV was not intentional, the appellant's sanction is to remain at a 4-year period of ineligibility pursuant to Article 10.2.11 of the WADC. Alternatively, the appellant has argued that the principle of proportionality should apply here to lower the appellant's sanctions. Proportionality is inherent in the WADC, and for the freestanding proportionality to apply, the case has to be so exceptional that it would be unfair for the sanctions to stay as it is.
Counsel, so the appellants quoted the panel in Mario. What the appellant's arguing is that it's such a small amount, and that is it fair to sanction based on such a small amount? This is the basis of the submissions on the appellant side, from what I see.
Mr. President, proportionality comes in when the case is so unfair or unjust that the sanction is unfair, and it does not really tie into the amount the unfairness does not come from the amount that was present, but rather whether the appellant had taken all possible steps and the ADRV had still resulted despite the appellant taking all possible steps. Hence, the amount shouldn't be the key factor that would invoke the freestanding principle of proportionality. Rather, it's the circumstances the appellant was in, and in this instance, the appellant was simply not innocent enough. Rather, was she careful enough that this ADRV was completely unavoidable or that she had such little fault, because as it stands, there were many factors she had failed to take and many steps she had failed to take, so that there's no innocence here that would invoke this principle that has a very high threshold to be invoked.
Counsel, the appellant saying there was no performance benefit taking the substance. So, I mean, essentially it would be a sanction over no effect, right?
As my co-counsel had submitted, that the benefit explained in Dr. Manan's report in Exhibit 4, there's still the benefit of fat loss, which could have helped the appellant. Besides the benefits that the appellant has covered, there are still other benefits that the athlete could have received to build muscle mass. Sorry.
Oh, to build muscle
To build
mass.
muscle
Is
mass.
this what it says here? Which
It's
line?
on Exhibit 4, paragraph 2, under context.
So sorry, Counsel. So that means you're trying to put forward an argument that the athlete took this substance previously, and by the time she was tested, it was already depleted in the body. So that's why the amount was very little.
Yes.
Okay.
Hence, the athlete was the circumstances in which the athlete had incurred this ADRV is simply not exceptional enough, nor is it substantially unfair on her part that would warrant the invoking of this principle of proportionality to lower her sanctions. Lastly, if this panel rejects the appellant's appeal, it is submitted that the appellant should grant the respondent a contribution of 10,000 Swiss francs to their costs, since there is nothing to suggest that the conduct observed and the financial resources of the parties are anything but routine in the present proceedings, and 10,000 is in between the typical amounts awarded of 0 to 20,000 francs. And it is for these reasons that we respectfully submit for the respondent.
Any questions?
Whenever you're ready for rebuttal.
Mr. President, Mr. Arbitrator, the appellant for rebuttal. Now, the respondent has made much of the fact that she understands what was written on the app or what was written on the control form likely means that she understood English enough to make her anti-doping education being in a non-native language irrelevant factor. However, we submit that there is a logical premise gap in the fact that she understood the app does not automatically mean that she understood the education that was delivered to her. And this is further compounded by the fact that it was delivered to her 4 years ago and likely will not be retained very well by the appellant. And for the respondent submission on fault, the appellant submits in rebuttal that the standard should not be that high. In the case of Arijan Ademi, the athlete there had a significant fault because they had failed to conduct an internet search where there had been many warning signs like bottle tampering and above all. So in rebuttal, the appellant submits that the standard should not be that high because there just isn't that many or that pertinent warning signs in this case. Thank you.
Members of the panel, the appellant has suggested that the level of fault should be lowered in this case. However, this panel must take note of the totality of the circumstances. Here, the appellant has failed to conduct a reasonable search. And a reasonable search is something which the WADC codes mandates for athletes to do, because this is in the definition of what constitutes a contaminated product. And so the statute requires athletes to do so. And on the second point, that the appellant the question of English is neither here nor there on whether the appellant had understood the education she received. On this point, the respondent still submits that the appellant is conversant in English, and beyond that, the appellant also had, at the point in time, notice of the fact that there were other doping cases during that instance, because in the 2024 Summer Olympics, there was a spate of contamination incidents, such as the ones relating to the 21 Chinese swimmers or the American sprinter, and she is an avid user of social media, and so she should have known that there was a possibility of contamination. Unless I may be of further assistance, this concludes the respondent's rebuttal.